On this episode of Law Weekly, we'll look again at the Petroleum Industry Act and the move by the president seeking some amendments to the legislation. We have the views of an oil and gas expert, Aderemi Fagbemi. Also showing on the program, a new legal year begins as the Lagos Judiciary officially resumes work, plus a recap of some of the top trending legal stories. Hello and welcome to the program. I'm Shola Shoyeli. It was on Tuesday, September 21st, that President Muhammadu Buhari wrote to the National Assembly seeking amendments to the Petroleum Industry Act. This move is coming less than 2 months after the president signed the bill into law, and this has raised questions and concerns about whether the bill was properly scrutinized before it was passed and whether this will stall its implementation. My guest on the show today is an energy and natural resources expert with experience spanning about 2 decades. Aderemi Fagbemi has been recognized by leading ranking firms such as Chambers and Partners Global and IFLR 1000 as a leading lawyer in the energy and resources industry. She's been involved in the development of legal, regulatory, and policy framework documents in the oil and gas and power sectors, and she agrees that someone dropped the ball with scrutinizing the PIA as passed.
When I heard about it on the news a couple of days ago, I smiled to myself. I was like, what? So soon? When a lot of people are still even reviewing and trying to understand and grapple with the, the provisions of the act. But yes, as to whether the president has the right or the powers to ask for an amendment of the act, just
weeks after
he had assented to it, the very simple and direct answer to that is yes. Okay. It's not a power. It's actually a right he has as another stakeholder, just any other Nigerian citizen, actually any other stakeholder. So he is not going to be, demanding. Okay. He's just going to be appealing to the National Assembly.
More like lobbying them.
Yes, basically. And if the National Assembly see reason why they should be making that amendment, yes, he can make it. As we're aware, the Constitution by Section 4, grants or vests the legislative powers, of the country in the National Assembly, and goes further to say that the National Assembly, which is the Senate and the House of Representatives, can pass a bill which the president will then assent to. There's nothing directly, no provision directly in the Constitution that talks about amendment. But if you look at the Interpretation Act, Section 10 to thereabout, I think it basically says that where an enactment has vested a right or permits someone to carry out a right, then it is assumed that every other thing for that act, to be properly executed, as it were, it's assumed that those rights are also given to that body. So basically, the National Assembly, just as like any other time, has the right to make laws and to amend those laws. And so if the president is appealing to them to amend the laws, if they see reason why they should, that's the Senate and the House of Assembly, then that can be done. With regards to whether it will stall the process, he shouldn't. So the PIA is an act as it is right now. Okay. So things should go on as they should. And I actually think it was because the president was trying to actually start to kickstart the process of enforcement, by appointing certain people that he realized, as it were, that certain provisions need to be changed. And so, yes, it's legal.
Have we been down this road before? There's an assent given and then we ask for amendments after. Has it ever happened?
I do not recall any such. Nothing comes to mind. But yeah, it's unusual. It's irregular, but it's legal.
It's legal. Yeah. Okay, there was also something that you said about is like any stakeholder, seeking an amendment. So does that mean that any other stakeholder can also ask for an amendment?
So the thing is, right now, the PIA is just an act like any other act. So it doesn't matter whether it's 2 days down the line that you're asking for an amendment or 20 years down the line. The point is, it's an act of the National Assembly. Stakeholders, interested parties can decide to seek for an amendment, but they will go through the regular channels and seek the amendment from the National Assembly. And the National Assembly is minded to consider it, then they will.
The amendment that is seeking, I see that it's an administrative one of membership, expansion of membership. And the president in his words said, because it has not addressed the principle of balanced geopolitical representation of the country. So he wants the intervention of the Ninth Assembly to correct this oversight in the interest of our national unity. So this expansion of membership,
Is it really necessary, this amendment, do you think?
He's looking for, the president that is, he's looking for an amendment with regards to membership of the board of the Nigerian national, the upstream regulator, basically. That is the Nigerian National Upstream Regulatory Commission.
Yes.
Yeah?
Nigerian Upstream.
The Nigerian Upstream Regulatory Commission.
Yes.
And then he's also looking for the same kind of amendment to the composition of the board of the Nigerian Midstream and Downstream Regulatory Authority.
Yes.
They have similar provisions with regards to the composition of the board, and is seeking for an amendment. Now, the amendment basically, or should I say the provision of that, or, you know, of the commission, the board of the commission and the board of the authority, there is a particular provision, section 11 and section 34 respectively, that that seeks to appoint two non-executive members to the board of the commission, non-executive commissioners to be precise, to the board of the commission and the authority respectively. And so what the president is saying is those two non-executive commissioners should be increased to 6 in order to, you know, meet the requirements of a federal character, basically meet the, you know, cut across the 6 political zones of the country, which, yeah, is fine by itself. But my concern is that someone dropped the ball somewhere. This bill, the bill was passed, you know, was assented to by the president, like you said, merely 40 days ago. What happened? We've had previous versions of this bill where we had an interagency team set up by the executive, you know, reviewing the bill and submitting their opinion to the National Assembly for the National Assembly, you know, to look through before they even pass, you know, and before it goes to the president for assent. So I'm thinking what happened, you know. And the interesting thing about this is that, if you recall, in 2018, the Petroleum Industry Governance Bill was passed by the two houses of assembly, the Senate and the House of Assembly. I mean, the House of Reps, sorry. And it was just waiting for the president to assent. Now, a little history to the Petroleum Industry Governance Bill. At a point when, you know, there seemed to be a lot of hold up with regards to passage of the PIB, we decided that maybe we need to break it down into different sections, and let's take it one at a time. Let's take a section, deal with it. When stakeholders are fine with it, we can pass it. And so they were able to achieve that with the Petroleum Industry Governance Bill, to the point of taking it to the president for assent, where it was stopped. Now, fast track down the line, this is 3 years down the line. Even though the president did not assent at that time, this bill was before the president, and I would think that the executive would have looked thoroughly at this bill. Because, guess what? The same provision with regards to the constitution, the two non-executive members, commissioners, that same provision was in the PIGB, you know, as of 2018. And so, at the very least, they might as well have looked at those provisions. And another thing that I read,
that they tally.
Yes, that, you know, no, it was the same thing. So if they had an issue,
the
same two members. Okay. So if they had a problem with it at that time, they might as well have flagged it. So that now. Yeah, and then you have the president signing. It's a bit untidy for me. And then I'm not privy to the letter to the Senate. And one of the things that I hear that the president asked for is what you just said. I've also heard or read that the president also asked that the ex-official members, you know, in that in the composition of the board should not be, you know, once the president appoints them, there is no need. There should not be need for Senate assent, because they are already civil servants, as it were, you know. If that were the case, then it seems as if should I say the president or his team did not really understand or did not really go through the provisions of that bill, because that particular provision basically actually says, so the president has the power to appoint all the members of the board of the commission and the authority, and then the National Assembly would assent. But the provision actually says, except for certain sets of people. And these sets of people are the ones that are the ex-official members. They are the representatives from the Federal Ministry of Petroleum Resources, representative from the Ministry of Finance, and the representative of the authority on the commission, and the representative of the commission in the authority. You know, so those people, there is already a provision in the Act that says that they do not need the appointment of the president and the assent of the National Assembly. So
this amendment is not necessary?
This particular one I'm talking about, it doesn't seem, it's not necessary because they've been exempted as well. So if the president is asking for an exemption, then it seems as if someone is missing something somewhere.
Okay.
Yeah. I also read as well that they're asking for the some reporters said they're asking that the ministers, the Minister of Petroleum Resources and the Minister of the
removal of the Ministries of Petroleum Resources and Finance from the boards of the two institutions.
Yeah. Okay, so if it's just the ministry, so representation. So what we have on the boards right now is representation from those ministries. Now, if that is what the president is talking about, yeah, to an extent he has a point. One of the arguments that was canvassed was the fact that ministers have policy-making powers and they have a portfolio with regards to policy, supervision, and government representation in international fora and all that, and that should be enough, and they don't have to be members of the boards of these agencies. Yeah, to an extent, but then again, like I said, in the old PIGB, this provision was there. Who missed it? And bear in mind that the minister is still supervising, to an extent, these agencies, and there are certain roles that he or she has to play in this, you know, in guiding the execution of the functions of these agencies. So if they need to have representations, why not? The only place that I would think that maybe the representation from the Ministry of Finance and the representation from the Ministry of Petroleum Resources may not be necessary with regards to the NNPC Limited. Because we're looking for a corporation that is, or should I say a company this time around, no longer a corporation, a company that is in step with times and that is a properly run profit-making entity with, you know, with less bureaucracy, as it were. So the less of political appointees we have on that board, the better for, yeah. Yes, so I think that's the only place where I think it's probably necessary. But like I said again, these representations were there before. Someone dropped the ball somewhere, but here we have it. That's it.
What else? I know these are the areas that the president has put up for amendment, but as an oil and gas expert, what other areas do you think, now that we have an opportunity for an amendment, that we probably should be looking at?
$1 million question. I think, interestingly, even when the PIB was still ongoing, you know, when it was still a bill, you know, over the years, we've had different people, stakeholders, you know, raise different issues. You know, the PIB should have this, should not have this, should represent certain interests and all that. And I think the debate can go on forever. Rarely across the world would we get a perfect legislation. Rarely do we have that. But what do we have? I think the important thing is, first of all, I'm happy that it has passed finally. It may not be perfect for all stakeholders. It's difficult to satisfy everyone at the same time. But I think we have a bill, or an act, as it were, that has tried to address certain issues and should be able to stand up to any other act of its type.
Anywhere in the world. Anywhere
in the world. So having said that, I've had arguments being canvassed about the fact that this is the time for the president to also look into the argument of the host communities that the trust fund that is to be set up, you know, based on the provisions of the act, should now be 5% rather than the 3% that we have in the PIA at the moment. Now the thing is that when the National Assembly passed the bill, you know, it's canvassed for 2.5%, you know, of the total annual expenditure, the previous year's annual expenditure of the operating entities, the licensees and lessees in the both upstream, midstream and downstream operations, you know. And then when the ad hoc committee gave their recommendation, they asked that the upstream operations should be 5% equity and then 2% for others, probably midstream as it were. Yeah. Now, the bill says 3%. Should it be 5%? Should it be 3%? This is not something that I can talk about. It is very political, yeah, and there are a lot of passion, interests involved in this. Sure. But what I would say is this: if the 3% is properly managed and utilized, I mean, it will bring about a lot of change that the communities are asking for, and nobody will be worried about the percentage, whether it's 2%, 3%, or 5%, or even more. I think what the host community should be looking forward to is seeing something happen. And I really do have faith that because the operating companies, the oil and gas operating companies, are going to be involved in this process, it's likely to have more success than without going into details, other provisions that have been made for the development of those communities, and we should just wait and see.
Welcome back. The Lagos State Governor, Babajide Sanwo-Olu, has assured the state's judiciary of its continuous cooperation and support to ensure improved access to justice for all citizens, irrespective of social and economic status. This assurance was given at the ceremonies to kickstart the 2021-2022 new legal year. Simultaneous Thanksgiving services were held by the judges, magistrates and judicial staff workers at the Lagos Central Mosque and the Cathedral Church of Christ Marina, and this was closely followed by the parade of guards at the Tafawa Balewa Square, signaling the official commencement of activities in the courts. After a month-long annual vacation, the Lagos State Judiciary has officially commenced the 2021-2022 new legal year. The leadership of the bench, led by the Chief Justice of Lagos, Justice Kazim Alugba, and the administrative judges, led out other judges, the magistrates, lawyers, and judiciary workers to Thanksgiving services which held simultaneously at the state's Central Mosque and the Cathedral Church of Christ Marina. At the church, the Anglican Bishop of Awori Diocese, Right Reverend Akiatere, told the judges and lawyers to continue to uphold due process.
There is going to be God's judgments for all our insincerity, perversion of justice, and for all the vices in the bench and in the bar. Are we no longer the voices of the voiceless? Are we no longer the defender of the cheated? Are we no longer the peacemaker of which we are ordained to be? Brethren, the soul of Nigeria is in your hands. Whatever happened in Nigeria, and whatever happened to Nigeria, God will ask you.
At the mosque, the lecture dwelt on the essence of effective administration of justice and the legal and religious perspective of the gains and pains of the COVID-19 pandemic so far.
We have good cause for thanksgiving. Not only has the judiciary survived the disruption of NSAS protests, the closure due to COVID-19, etc. But the judiciary has been able to continue the excellent work that has been done in the past. Specifically, I'm referring to the continuation of the multi-door courthouse, which the Chief Judge is paying special attention to. And I'm particularly happy to note that the bondsman scheme has been put in place in order to ensure elimination of professional shorties. For all these, it seems to me very appropriate that we should regard this as a thanksgiving.
The Lagos State government also used the opportunity of the ceremony to pledge its continued support to the judiciary.
We shall continue to strengthen the capacity of all government agencies, departments established to provide support for the vulnerable citizen to protect their rights and obtain justice. I also wish to assure that we remain committed to the ongoing reconstruction and renovation of our courts, including digitization projects.
After the Thanksgiving services, the Chief Judge of Lagos inspected the parade of guards. The ceremony, which usually takes place at the State High Court in Judiciary, held at the Tafawa Balewa Square owing to the fire incident that razed most parts of the Judiciary Court last year. The CJ spoke about what to look forward to in the new legal year.
You know what happened to us last year, but glory be to God, we are getting back on our feet, and certainly you will see a more rapid disposition of cases. Now we are likely to have more judges, hopefully before the year runs out. Quite a number of judges are very retired, so naturally that will affect the pace at which we can dispense with cases. But by the grace of God, we'll get some more judges and things will come back to full throttle.
Where are we with digitalization? That's something that you said would aid.
Yes, you know that digitalization is something that has to be well planned, well deployed, with all the myriad of problems we have. Connectivity is one and so many others. So I can say that we are midway through in some areas. In the High Courts now, we are test running a digitalized system in the High Courts. And as soon as we perfect that, the consultants would, plug in the holes wherever we see mistakes or handicaps. And then we can deploy to all the states. Right now, we are deploying to 10 courts. In the magistrate courts, that is in the planning stage. But as for, let me say primarily, every court in Lagos State should now be able to do teleconferencing. You can at least do video conferencing and take cases that way. You can do Zoom. We're expanding our coverage of Zoom hearing as well. It used to be a number of courts, and then you have registrars, ACRs deployed to assist. But now we're going to train all the registrars of all courts to be able to conduct Zoom hearing.
And just before we go, let's bring you a recap of some of the legal stories that made the headlines.
The battle to determine who collects value-added tax will now shift to the Port Harcourt Division of the Court of Appeal as from October the 7th. The decision was taken after the Court of Appeal in Abuja granted a request by the Lagos State government to join Rivers State in the appeal filed by the Federal Inland Revenue Service. At the resumed hearing of the matter, the court ordered all processes filed to be served on the Attorney General of Lagos State, Mr. Moyosore Onigbanjo. At the last sitting, Mr. Onigbanjo had told the panel of judges led by Justice Haruna Samani that the state will be impacted by the outcome of the appeal by the FIRS. He urged the court to uphold the application for joinder, arguing that the case of joinder sought to prevent multiplicity of action. Meanwhile, the government of Oyo State has also asked to be joined in the suit. The suit instituted by the Attorney General of Oyo State, Professor Oyelowo Oyewo, is seeking an order of the appellate court to enable Oyo State to join the suit as an interested party. According to the AG, the government of Oyo State was unaware of the suit between the Attorney General of Rivers State and the Federal Inland Revenue Service at the Federal High Court until the judgment was delivered, and this decision will affect the collection of VAT in the state. In other news, the Federal High Court Abuja has fixed November the 24th to hear a suit filed by a coalition of women's society organizations against the federal government, seeking a declaration that the failure of the federal government to implement the 35% affirmative action policy is illegal and unlawful, and a violation of the National Gender Policy 2006. The date was fixed following the inability of the trial judge, Justice Donatus Okorowo, to hear the suit due to urgent official matters. All parties involved in the matter were present in court. The women organizations are also seeking an injunction restraining the federal government from further exercising the statutory power of appointment, violating the 35% affirmative action policy. Still in Abuja, another federal high court has barred the Economic and Financial Crimes Commission from retrying the former governor of Abia State, Senator Orji Uzor Kalu, on the 7.1 billion naira money laundering charges earlier preferred against him. Delivering the judgment, Justice Inyang Ekwo holds that the verdict given by the Supreme Court on May 8, 2020 did not order a retrial of either the former governor nor his firm, Slock Nigeria Limited. Justice Ekwo further added that the Supreme Court only ordered the retrial of the former Director of Finance in Abia State, Mr. Jones Udogu, who was the appellant before it. Meanwhile, the EFCC says it will appeal the ruling by Justice Ekwo. The Commission argued that the Supreme Court did not order the retrial of Kalu, that it amounts to cherry-picking for him to profit from the decision of the Apex Court nullifying the conviction of his co-defendant, Ude Udeagu, but is not prepared to face the burden of retrial. And we round up with the report that the Federal High Court has fixed October the 14th for the rearrangement of the former National Publicity Secretary of the People's Democratic Party, Olisa Metu, over alleged 400 million naira fraud. The date was fixed following the absence of the new trial judge, Justice Obiore Gwatu, in court. Mr. Metu's retrial could not proceed despite his presence and all the parties involved in court. The Court of Appeal Abuja had on December the 16th, 2020, nullified the Federal High Court judgment that convicted and sentenced Mr. Metu to 7 years imprisonment for money laundering. The appellate court held that the judgment on the trial judge Okon Abang was tainted with bias and subsequently sent the case file back to the Federal High Court for retrial by another judge. Mr. Metu will be retried over allegations of receiving the sum of 400 million naira from the former National Security Advisor, Colonel Sambo Dasuki, prior to the 2015 presidential election without contract approval or execution.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Sheele. Thank you for watching and see you next week.